Are you ready, Mr. Mears? How about Mr. Siefert? You ready? Yes. Thank you. Well, supposing or not, it's your turn. Are you ready now? You may begin. Thank you.
Mears, I'm from Iowa City. I'm pleased to appear in front of you in what is bound to be a somewhat unusual case, that it is as close as I can think of as to a class action post-conviction. We don't normally have those, but that a little over 2.5 years ago, I was called by Judge McCall over in Jasper County and asked to handle a whole group of cases that had been filed there, 7 of them in exact. I agreed to an appointment, even though, as he points out in his opinion, I pretty much knew at the time there was going to be a question whether I would get paid for that appointment. This case has been coming for a long time. I do a lot of work with inmates who are in the prison, and that essentially for the last at least 15 years, it's been the case that inmates who are sex offenders have wound up practically discharging their sentence because of the requirement that's been imposed from somebody that you have to finish treatment before you get a parole. It's not exactly an unreasonable position, but that the way it has worked out is that there's this problem. And the hearing we had 2 years ago in 2 days, September 18th, I think it was, 2019, at the prison, the last time I've been inside the prison, I might add, that I just, in thinking about it, I remember you have to walk through the halls of the prison to get back to the place they do, the Judge McCall does the hearings, and there are hundreds and hundreds of people, and just being around that number of people is hard to imagine almost at this point. So we took testimony for almost all day. The seven inmates who were, I might say, a fairly decent cross-section of sex offenders who, in fact, are mostly low risk to reoffend and wanted to do treatment, and in some cases had been in prison for quite some time, 8 or 9 years, without any realistic opportunity to be released because they had been delayed. Treatment had not been available.
Mr. Mears, each of the petitioners or the prisoners, they are parole eligible, isn't that correct?
That's right. None of them had mandatory minimum sentences.
And if I understand the testimony correctly, the Board of Parole can consider these offenders for parole and make a decision to grant parole, even in the absence of SOTP.
Sure. I mean, the Board of Parole in those cases can grant parole the day after the person arrives at prison.
That is not their practice, but they could do that if the board could do that if it chose to do that.
That's absolutely correct, even though we did, in fact, make a good record on that point, which was that the Board of Parole representative who testified explained that it was the board practice not to release sex offenders where treatment was recommended by the DOC until after they had completed treatment. And then we also, an important part of that record also was the fact that the Department of Corrections acknowledged that the method they used for selecting who went into treatment did not involve the Board of Parole at all.
If those things are true, why isn't affording the offender the opportunity to make a statement to the Board of Parole and argue for release without the completion of SOTP sufficient to satisfy due process?
Well, that the question, because the Board of Parole wouldn't give them that opportunity because of a practice or policy of not awarding parole to anybody unless they have.
But the right to due process isn't the right to have a decision go in one's favor. It's the right to be heard, and if the board does do that, and they, you know, I don't know what the evidence would show if they've ever granted parole to somebody who's never completed SOTP, but you're making a constitutional claim, and as I read the cases, it's just a right to be heard on the issue, not the right to a particular decision or substantive programming. So help me out with that piece.
If the board were to say, we're going to listen to you next week, even though that doesn't happen because the way the Board of Parole handles their annual review is on paper, they decide whether or not they're going to interview somebody. And if they are going to interview somebody, they do that the next month. And that none of the people none of the clients had ever appeared in front of the board, even though they could have made a written submission. But if the Board of Parole said, you know, next week you can say what you want, but we've already decided you're not getting out, that's not a meaningful opportunity to make your case for getting out. Moreover, what you have here is a third party, the Department of Corrections, essentially exercising what could be thought of as a pocket veto on the ability to get out. That gets back to the Bonilla case. In Bonilla, there is absolutely a clear constitutionally protected right of a juvenile offender to have a meaningful hearing in front of the board. And in Bonilla, the court said, it's not, if the Department of Corrections isn't going to give you treatment and the board requires treatment, there's something constitutionally wrong with that.
Well, but let me ask you, if the board is aware of what the Department of Corrections is doing, I mean, there's limited resources. They're trying to figure out a way to get SOTP services to a substantial number of people. If the board is aware of that, and the DOC isn't what I'll call cherry picking. I mean, they're not looking through and saying, "Oh, Smith, you know, he needs to be punished more." I mean, you know, that would be a real problem for DOC, it seems to me, if they were doing that kind of thing. But if the problem is this, that there's limited resources, the DOC is trying to come up with kind of a rational plan to allocate the resources on SOTP, and the Board of Parole is aware that they're doing that, is there a due process problem under those facts?
Well, I mean, the facts that we have are the Board of Parole is not going to give a meaningful review of any sex offender who hasn't finished treatment.
And is that a due process problem?
That if the Department of Corrections is not allowing someone to go into treatment until near the very end of their sentence, that's a problem. That's interference with the constitutional right to have a meaningful review of your release request.
This kind of get back to the point Justice McDonald raised. Are we talking about a substantive right, or is it largely a procedural right? Because it seems to me what you're really arguing for is a substantive right to treatment. Am I correct?
Where treatment is a precondition of parole, where you have a constitutionally based right to be meaningfully considered. I mean, that's what you said in Bonilla.
Well,
and in
no,
Bonilla,
it's also, remember, Bonilla was someone who committed his crime as a juvenile, and there's sort of an added layer of rights there for to be released, have an opportunity for release on demonstrated maturity and rehabilitation. But I mean, if we're going to say there's a substantive right to rehabilitation, that is a pretty broad proposition that's really going to get us involved in, you know, kind of managing the prisons, right?
and I don't think you have to go there. You're not saying that there's a substantive right to rehabilitation or to any particular treatment, but that if you have if the state legislature sets up a parole system which creates a liberty interest in a meaningful opportunity to get out, and that the Board of Parole conditions getting out on doing treatment, that there's a problem if the DOC won't let you do treatment. And
Counsel, given the limited resources, how would you if you could decree a change in practice, how would you line up the people? How would you sequence them? Right now, as I understand it, they're doing it by data release. Whoever's releases sooner gets into treatment earlier. What should they be doing differently?
Well, for one thing, that if there were to be a violation, what we suggested here was that what the court should do is ask the Department of Corrections to come up with a plan to fix this, to make it better, to give people more of a realistic opportunity for getting out.
Does that mean more resources?
I'm sorry?
That seems to me to imply more resources.
Well, that's up to them. I mean, they can go to the legislature and insist on getting sort of more bed space, that they could, in fact, one of the things that I suggested they could do was identify the 100 individuals who are on that waiting list who are low risk, and those people could be recommended to the Board of Parole to do treatment in the community. One of the little parts of the record that we made was that the curriculum that's used in the treatment program at at Newton is now the same curriculum used by every judicial district.
Mr. Mears, at what time does the right to treatment attach? So how much time does an offender have to serve before, under your scheme, he is entitled to sex offender treatment?
Well, again, I take issue with characterizing it as a right to treatment. There is a right to a meaningful consideration for release by the Board of Parole, which means that the Department of Corrections should not be permitted to pocket veto that meaningful release.
Okay, well, tell me how long, though. I mean, when does the treatment have to occur? So, for example, Mr. Bomgaars has a 40-year sentence. At what point is he required to be allowed to access SOTP?
That one of the suggestions that I made to the district court was that the Department of Corrections could involve the parole board in making a decision as to when someone should go to treatment, so that they could, the way it worked 20 years ago was that the Board of Parole reviewed sex offenders, actually reviewed them, and coded the inmate such that the Department of Corrections would know it was time to put them into treatment.
But do you think an offender should have an entitlement to immediate access to SOTP, day one from entering a prison?
I think that a person serving a 5-year sentence or 10-year sentence for sex offense in the 3rd degree, where it's non-forcible, for example, at their first annual, the Board of Parole should be able to indicate to corrections that this person doesn't have to spend 90% of their sentence in prison.
It seems like, and maybe this goes to Justice Appel's point, the DOC is trying to prioritize the resources that they have available by looking at release dates and making SOTP available as quickly as they can to these offenders. And if you can't articulate a different standard, then why would we second guess what the DOC is? So if you were drafting an opinion, what would you say would be the time at which an offender is entitled to receive SOTP in a way that's different than what the Department of Corrections is doing?
I would say that at the Department of Corrections, at a bare minimum, needs to involve the Board of Parole in the decision of when someone goes to treatment.
Aren't you just playing whack-a-mole then? You'll move people around and there's going to be another mole that pops up. I mean, you're just going to shove one person to the front of the line and you're going to push somebody back behind who, according to the old rule, was up next. So without the resource issue being addressed, how does that proposal help?
That's correct. I'll get the whack-a-mole out. I mean, it is true as a mathematical matter that unless you presume the Board of Parole is going to parole low-risk offenders to do community treatment, and the Department of Corrections will recommend that to the Board of Parole.
That's one option that's non-monetary related. And do you have any other options that may a combination? What other options or suggestions do you have besides the perhaps early release into community treatment?
Well, I do think that there's a fairer way of playing whack-a-mole. I mean, that the fairer way is to involve the Board of Parole. I think, for example, the Board of Parole, you could have the exact same thing that they do here, and that the Board of Parole could have the ability to give somebody a 2 or 3 year boost on the waiting list. They testified that one of the exceptions to the very cold calculation was that when a person had no special sentence, and I assume people know what a special sentence is, and most of sex offenders who are now in the prison have special sentences. But if somebody doesn't have that, what they do is they give them a 3-year goose on the whack-a-mole system.
But again, so
When?
In the absence of unlimited resources, giving someone a boost necessarily means somebody else has to wait longer.
That's true. And I suggest that if, but remember, what's happening here is that these people are being given a mandatory, what's called a silent mandatory sentence. You get a 10-year prison sentence, and that going into it day one, you know how much time they're going to serve. Pretty much.
Okay, so what you're really saying, if I may recharacterize it, is that the Board of Parole cannot categorically say, we're not letting you out without SOTP. There's got to be an individual opportunity to make your case before the parole board. And it's the categorical rule that gives rise to the due process problem. Is that, I mean, that's what I'm hearing.
Well,
Correct me.
I do think two parts of what you just said. I mean, one is I do think a third party can, in fact, analytically interfere with a due process right. You have a due process right to a hearing, and I do think
Yeah,
that...
okay, but the board, I'm assuming, for my hypothetical, let's assume the Board of Parole is fully aware of what DOC is doing and thinks it's just fine.
Well, that avoids doing work. I mean, they don't
Well,
have to...
well, it could be more than that. I mean, a rational parole board member could say, you know what? We don't have time for, and the ability to manage this SOTP program. I understand exactly what the resources are. I understand how they're stacking them up. I think that's fine, and until you get SOTP under the DOC program, there's no release. That's a categorical rule, and you're saying they can't say that, I think. Is that right?
Well, and the real... I said this case has been a long time coming, and one of the reasons it's been a long time coming is trying to figure out how you get this case in front of a court is really complicated. Because under Belk, you said you could bring the Department of Corrections in under the post-conviction statute. That, however, as was pointed out by the state, the Board of Parole is not actually a party to this suit, so that the court is probably powerless to order the Board of Parole to do anything.
If you'd like to wrap up on this first end, we'll come back to you.
That, again, what's created is a silent mandatory sentence, and that this is created by, and what's wrong with this is that there clearly is a constitutionally protected interest in having a meaningful parole review. And that's been denied by the Department of Corrections in reading the Board of Parole out of the process and not allowing sex offender treatment until the very end of a sentence.
Thank you, Mr. Mears. Mr. Siefert.
May it please the court. I think the clear result in this case should be that this court upholds the policy and practice of the Iowa Department of Corrections in sequencing inmates for placement into SOTP based on their discharge date. That is a manifestly reasonable and fair method of dealing with the logjam of inmates needing treatment. They have been tasked in Iowa Code Section 903A.2 with operating such a treatment program because earned time for sex offenders and those needing such treatment is conditioned on completion of the treatment. And so what they're doing is they're trying to effect a system in which every inmate has an equal and fair opportunity to receive that treatment prior to their discharge date. And so what happens is when you have hundreds of inmates on a waiting list with more showing up every day, there's simply no way to individually assess fairly every single inmate within IDOC and sequence them on some perfect method of who is most deserving of a spot first. And so what IDOC has done, and what I think, you know, within the Belk framework of what the claim was allowed to be, where the court should investigate whether IDOC's practice of having delayed treatment and then not recommending parole without the treatment, whether that unconstitutionally interferes with a statutory liberty interest in parole. I think the answer to that has to be that that does not amount to an unconstitutional interference with any liberty interest.
Counsel, sorry.
Yeah. Suppose the Board of Parole said, we're going to require SOTP treatment for this 100 inmates. And the Department of Corrections said, well, we're not going to get to it for 5 years. And so each of the 100 people were not considered for parole for that 5-year period. Would that be a de facto mandatory minimum sentence contrary to parole statutes?
So, Justice Apple, I think my short answer is no. I think that raises
and why?
I think that raises a few questions. The first is, which my argument about ripeness, I think, kind of touches on this, which is what we have largely here is a bunch of inmates within IDOC who have no, I'll call it a realistic expectation of parole because they've already been in front of the parole board who have the authority to parole them. They've gotten back denials that list a number of codes, one of them being DR7, which...
but I want you to answer the hypothetical, which you may distinguish because the facts are different. But we've got 100 inmates. They must complete SOTP. According to the parole board said, I'm sorry, you're sex offenders. You have to complete this treatment program. And the Department of Corrections says you can't get it for 5 years. You're in our planning process, but it's 5 years out. Wouldn't that be a due process violation?
And there, I will still say no, and I apologize I didn't get there fast enough. I think my response more briefly is this. I think the actual answer to that question is that to the extent there's a liberty interest, a statutory liberty interest in parole, that is a due process interest with the Board of Parole to grant you certain protections and processes to prove that you are eligible. I think the issue here, and with your hypothetical specifically, would be Ms. Muehlhoff with Iowa Board of Parole testified at the hearing. She's well aware, and everyone at the Board of Parole is well aware, that they are free to release someone anytime they want. So even if IDOC said no, we think our process is fair, we're not going to prioritize people based on what you are telling us, I still think the problem would be that we're kind of in this untethered, unmoored area here because the due process right would attach to the kind of the parole board process. What Belk says is that you could potentially have the Department of Corrections unconstitutionally interfering, and my argument would be that no, you can't actually, because IDOC is incapable of taking away that power. The Board of Parole could always just look at the person and say, they've been sitting there for 5 years. We thought they were otherwise perfectly acceptable to release. We made the determination that they could be done so without detriment to the community or themselves. And so we're therefore going to make this assessment at this point that we think they are low enough risk that we're willing to release them.
What about, what if it wasn't a resource issue? What if DOC had plenty of spots and plenty of resources to give SOTP for everyone and just adopted a policy, we're going to wait until you're within 1 year of discharge before, tentative discharge date before we give you SOTP? Would that be a due process problem?
In Your Honor, aside from the fact that I think that's obviously distinguishable from here, where that's not what's actually happened, there's no affirmative decision to deny treatment to anyone, I think my response would still largely be no. I think the crux of this is, and what Belk made clear, was that Belk's claim in that case was not against the Board of Parole, or their processes or policies, that the claim was really against IDOC and the delay. And I think the distinction is still that the Iowa Board of Parole is always free to grant a parole if they want to send a code to IDOC saying, please put this person in treatment, if IDOC otherwise wanted to back-end it. But absent some sort of actual link, and I think somewhat ironically, the evidence in this case shows that there is a pretty clear division between the Iowa Board of Parole exercising its authority and DOC exercising its. Absent some sort of conflation there, where IDOC was stopping Board of Parole from exercising its legislative authority, legislatively granted authority, I still don't think that IDOC can, as a matter of law, block someone from being paroled. And I think if it had a rational basis and a reason to want to back-end it, if it thought, for example, as I think in Belk was one of the offered reasons, that treatment is fresher in the person's mind when they leave and is therefore safer for society, I still think that could be a justified position, and so I wouldn't concede that.
In terms of the parole process itself, you have the consideration, and then the offender has an opportunity for 17A review of the parole decision, correct?
Correct.
And that's the procedural issue that we're really concerned about in terms of the due process claim under Greenholz, VTEC, et cetera. There's nothing that prohibits, at least as I understand it, and correct me if I'm wrong, the Board of Parole setting substantive standards that are difficult to meet. So if the Board of Parole said, under our discretion, we are not going to grant paroles until somebody's served, X percent or done these treatments, the procedural cases don't address that question, do they?
I don't think so, Your Honor. I think the procedural cases are largely more looking at whether the statutory language creates a liberty interest because there is no constitutional liberty interest. Obviously, that's different in Bonilla, for example, where now we are in that different universe dealing with the constitutional right to demonstrate maturity and things. But just within the context of the Board of Parole, I think they are free to establish their own guidelines. I think the testimony here is that even if it's not written down effectively, the guidelines they've established is that they're typically going to adhere to the the Department of Corrections' recommendation, and that if a person doesn't have treatment, they will generally conform to that, although they are aware they don't have to. And I think, again, that really is where this case needs to be kind of split apart and looked at separately, is I think...
Here's my problem with that. I mean, you're right, there's sort of two avenues that Mr. Mears could pursue for relief. One would be he could go to the Board of Parole and say, your policy is unreasonable of just following whatever DOC is doing and denying parole is if DOC says they still need sex offender treatment. The other way he can get relief is the one he has chosen, which is to try to get DOC to accelerate the SOTP treatment. And you're saying that's an avenue he shouldn't bother pursuing, that's not available. But in Belk we said, and I quote, an inmate may proceed under Iowa Code Section 822.21e when alleging an unconstitutional denial of his or her liberty interest based on DOC's failure to offer SOTP when SOTP is a necessary prerequisite to parole. So we told him to go this path, he's going it, and now you're saying, it's the wrong path.
Well, and so Justice Mansfield, I don't mean to tell this court that its prior ruling is something that's not possible. That's certainly not what I'm suggesting. What I'm suggesting is...
That's okay, you can say that.
What I'm suggesting is that I think if you look at Mr. Mears' arguments and what he presented, and then specifically if you look at the remedies he suggested as possibilities, I think his primary issue is with the fact that the Board of Parole is not giving individualized assessments other than just following the recommendation of DOC. And I think the related contention that he's making is that what he wants to see largely is more connection. He wants the Board of Parole, after doing that individualized assessment, to send information to DOC so that DOC can then sequence inmates for treatment in a more fair, equitable way. And I think the problem is that I think needs to be I think he needs to go to 17A and complain about that with an inmate who's denied by the board. I think here, and I'm again not saying it can never happen, but I think the facts of this case just don't warrant a finding against DOC in kind of the Belk type case. I think you could have a situation, for example, where DOC, I think it's a much different case even to argue, for example, under that alternate basis in Belk, where if DOC is to suggest that we have all the funding and all the resources to put everyone in today, and we're just choosing not to, then I think you maybe start to look at, and again, Benia's a little not on square footing, but that unreasonable reasonable withholding.
Then it sounds an awful lot like a pocket veto.
Sure.
As opposed to the pockets not being deep enough. Yeah.
Sure, and I think that's fair. But so my point is simply that I think largely what Mr. Mears is asking for is he wants relief essentially against the Board of Parole based on this interplay that he wants that isn't there.
But also, he's argued in his brief that he is asking us to find that there's a protected liberty interest in getting a parole based on the Iowa parole statute. He compares our statute to one from Montana, and in particular is citing the Allen case. I don't think the Allen case was referred to in your brief or a discussion about that. Can you help me understand what would the state's position be on that argument about determining that it is a protected liberty interest?
Sure. So the state's position on that, I think, is I certainly I don't think it takes a scholar to look at the different cases and see the similarity in language. The state's position is we don't concede there's such an interest. There's never been one found. And I think even the Supreme Court in later cases, specifically Sandin v. Connor, starts to backtrack a little on the Green, Holston, Allen style analysis using that mandatory language. I think later it goes on to looking at whether something is an atypical hardship that's not kind of the regular prison life type of situation. But other than simply saying those things and saying that the state doesn't concede it and this court has never found it, I can't sit here and say that the state of Iowa's parole statute is meaningful.
On the whack-a-mole discussion, you have got to be getting tired of hearing SOTP not happening is not, he has 7 cases in one filing here. Obviously, it's an issue that's not uncommon. On behalf of the state, what would you recommend short of funding? What could be done to address this issue?
Well, and I think there, Madam Chief Justice, I think the answer is that what should be done is what's already being done. I think the testimony of Sean Crawford, who at the time of this hearing was the director of the sex offender treatment program, he no longer is. There's another individual in his old job. He testified that a number of different things have been done to speed up the process and make it faster and fairer and move the completion of SOTP further away from discharge date so that inmates have an earlier opportunity of parole. The entire program was moved from Mount Pleasant to the Newton Correctional Facility so that all the treatment was happening in one place. That facility has at this point become essentially a sex offender-only prison for all intents and purposes, with classes running from, I think the testimony was 6:30 a.m. until evening hours. There have been efforts to hire additional facilitators to shorten the length of the program to make a consistency effort so that it can be streamlined, that facilitators don't have to pass inmates between each other to complete the program. And Mr. Crawford testified that that has ultimately led to a situation where I think he testified at the time of that hearing that the prior year was the first year he was aware of where they'd been able to get more people through sex offender treatment than were coming into the system needing it. And the increases in efficiencies he believed were going to continue to chip away and move that kind of gap between discharge and completion further away from each other to make it even fair. I think with the ultimate goal, if you infer it from his testimony, which I think is fair, of changing it into a situation where we don't get this, where inmates are able to get sex offender treatment far enough away that they're not getting a denial code from the Board of Parole where the lack of treatment is the only remaining hurdle. So that would be the state's argument that everything it's doing is already the correct solution. I think this court should heed Justice Waterman's dissent where he quoted Justice Scalia, basically warning against large-scale structural injunctions and policy-making decisions by the court. And so the state would ask that you uphold the decision of the district court.
Thank you. Mr. Mears?
I do feel obligated, Justice McDonald, to talk to you a little bit about when do you have the right to treatment, if there is such a right to treatment. What I would say that you have a right to treatment at the point in time when your right to parole is being conditioned on that treatment. Whether that right is violated depends on whether the response by the Department of Corrections is reasonable or not. Recognizing that, you know, for what?
If that were true with respect to these offenders, and you know the record better than I do, so please correct me. If I understand it correctly, based on the codes for denial in this case, none of these offenders are being denied parole based solely on the fact that they have not completed SOTP. Is that correct?
There may be something in the record that says that. I don't think that's the factual conclusion that you should reach here. I think the factual conclusion that was reached by the district court and was testified by the Board of Parole and the Department of Corrections was no parole until treatment, if treatment is recommended, period.
Let me state it differently. Each of the parole decisions are coded, is that right?
That's right.
With respect to each of these offenders, there were codes given and reasons for denying parole other than non-completion of SOTP. Is that correct?
Sure.
Okay.
Is that true as to Mr. Cross?
I'm sorry?
Is that true as to Mr. Cross?
I don't remember the particular code provisions. I mean, again, once I was told, or once I had in the record, that the Board of Parole would not parole people unless they did treatment, what the code was, I mean, you know,
but
20 years ago,
with respect to relief for each individual offender, not talking about the policy generally, if the Board of Parole codes the parole decision saying we've denied parole in this particular case because of the severity of the offense. So in terms of relief for that particular offender, SOTP is a non-issue at that point. Isn't that right? I mean, we have to look at each offender individually, I think is what you're saying.
Well,
but then you're saying, no, I want you to take a global approach and think about the policy.
If, in fact, I believed a code that said seriousness of the offense. But, for example, the point is, LaBelle, I believe, got a code, as I recall, that said, you know, get him into treatment soon. And that wasn't happening. I mean, that is that the Department of Corrections, in answers to interrogatories, said the Board of Parole plays no role in our sort of determination, our waiting list process. That I have a couple of other things I really want to respond to.
Counsel, sorry, over here.
Sure.
Hi. Respond to the state's argument that Section 906.4 doesn't create any protected liberty interest here.
Well, I mean, I think that compare the language of the two statutes. They're in Montana and Iowa, and they're virtually identical. When I look at the Belk case, that I think even Justice Waterman has language in his dissent that recognizes that there is some constitutional right in the parole process, some protected right. I don't think that's an issue. Again, it seems to me you posit a constitutional right, and then the question is it being violated, which gets you back to the question posited in Bonilla, which is if the Department of Corrections unreasonably interfering with that right. Again, when is that right to treatment triggered? I also think, you know, we talk about whack-a-moles, that when it quacks like a duck, it's a duck. I mean, when Bomgaars has been in prison doing remarkably well, most of these people had reasonably successful prison stays, taking college classes. One of them was a mentor and after 8 years or whatever it was, he's never gotten a serious consideration by the board. I mean, that's a duck. I mean, that he has got a silent mandatory, which wasn't imposed by a court. And that I might add, I think the notion, if in fact you can concretely show that it's a silent mandatory, there's a problem under the post-conviction statute under Section 822. It's the third one where the person is serving a sentence beyond the maximum. I never want to avoid the reference. There's actually and when we talk about what pigeonhole do you put a Belk case in? Is it A, B, C, and does it, where you put the pigeonhole depends on whether there's a right to counsel. That there's a case where the party is Philip Mears. I mean, I had a case sort of, I don't remember how many years ago it was, but that the question was whether the Department of Corrections practice of not allowing earn time on special sentence revocations and not awarding jail credit was in some fashion unlawful, and the public defender refused to pay me, saying that this was under E or F, and I convinced the Court of Appeals that in fact it was under C, where the person was serving a sentence beyond what had been authorized. I think that if in fact the evidence shows that there is a silent mandatory and that wasn't imposed by a judge, that's a problem under 820, under the third version, and I think people should be getting the right to
You may
counsel.
sum up by saying goodbye, maybe. I was being nice.
Justice Scalia is quoted in the state's brief in one of his cases about warning that judges should not sort of put themselves in the position of being a prison administrator or something like that it's not the role. That other times we hear that we have scarce resources and so therefore we can't do anything. The problem is that sometimes problems are presented where there's a clear problem that may even, in fact, be of a constitutional or statutory nature. We can't run away from the obligation to address those just because we think there's not enough money or because we think judges shouldn't get involved in something like this.
Thank you, Mr. Mears. Thank you. I did give you an open-ended opportunity. The case of Bomgaars versus State of Iowa is hereby submitted and court is adjourned for the morning. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.